What is aggravated identity theft in New York? When someone steals the identity of a deployed military service member and causes more than $500 in financial harm, New York treats it as one of its most serious identity crimes. Under New York Penal Law Section 190.80a, aggravated identity theft is a Class D felony carrying a maximum prison sentence of up to 7 years, distinguished from standard identity theft by two critical elements. Those two elements are a victim who is a member of the armed forces deployed outside the continental United States and a value threshold exceeding $500 obtained or lost under that service member's identity. New York organizes identity theft in tiers, with second-degree identity theft as a Class E felony, first degree as a Class D felony, and aggravated identity theft sitting at the very top requiring that deployed military victim element. Federal law adds another layer through 18 U.S.C. Section 1028a, which imposes a separate mandatory consecutive sentence when someone unlawfully uses another person's identifying information during and in relation to a qualifying federal felony. A qualifying means of identification under federal law includes a name, social security number, date of birth, driver's license number, passport number, or any other identifier tied to a specific individual. The predicate offenses that trigger federal aggravated identity theft charges cover a sweeping range of conduct, from theft of public money and bank fraud to visa offenses, immigration violations, and crimes under the federal fraud statutes in Chapters 47 and 63. Many people confuse 18 U.S.C. Section 1028 with Section 1028a, but they punish fundamentally different conduct, since Section 1028 covers general identity fraud while Section 1028a adds a mandatory consecutive sentence on top of any underlying felony punishment. That consecutive sentencing rule is what makes a federal Section 1028a charge so significant, because the added sentence does not replace the penalty for the underlying crime but is stacked directly on top of it. Under the dual sovereignty doctrine, a single course of conduct can expose a person to charges under both New York state law and federal law simultaneously, meaning a prosecution in one court does not automatically prevent a prosecution in the other. The same act, such as using a deployed service member's credit information in a fraud scheme crossing state lines, could draw attention from both Suffolk County prosecutors and federal authorities in the Eastern District of New York. When both state and federal authorities are involved, coordinated defense strategy becomes essential because decisions made in one forum can directly affect outcomes in the other, making experienced legal counsel critical from the earliest stage. Suffolk County criminal defense attorney Jason Bassett brings a background as a former assistant district attorney, principal assistant county attorney, and special assistant attorney general to every serious criminal matter he handles on Long Island. This law firm represents clients facing state and federal identity theft, fraud, and related criminal charges throughout Long Island and before the U.S. District Courts for the Eastern and Southern Districts of New York. If you are facing aggravated identity theft charges, a skilled lawyer can review the evidence, identify weaknesses in the prosecution's case, and build a defense strategy before any plea is discussed. Contact the law offices of Jason Bassett, P.C., located at 320 Carlton Avenue No. 4200, Central Islip, New York, 11722 by calling 631-259-6060 to schedule your consultation today.